Hello, my name is Yael Gamm. I'm a judge assigned to the Unified Family Dependency Division. The Dependency Division handles cases with families who become involved with the Department of Children and Family Services, or ChildNet. If your child is removed from your custody due to allegations of abuse, neglect, or abandonment, you are entitled to have a shelter hearing on that removal within 24 hours. At that hearing, you're entitled to have an attorney present to represent you of your choosing, or if you cannot afford that attorney, the court may appoint an attorney to represent you for the purposes of that shelter hearing. At that hearing, a judge will decide if there's probable cause for your child to remain out of your care. If that is the decision of the court, you can give names of people to the court and to the department that you believe are willing and able to care for the child upon an approved background screen and home study of their residence. You will be given a date at your shelter hearing to appear for your arraignment. At that arraignment, you can choose to either consent to the allegations in the petition or opt for a trial. If you do choose to consent to the allegations in the petition, the court will likely order services for you to assist you in regaining custody of your child. We have two therapeutic courts here in the Dependency Division. We have both the Dependency Drug Court as well as the Early Childhood Court. You can ask about either one of those courts during your arraignment hearing. If you decide you would like a trial in your matter, you are entitled to have that trial heard by your division judge. You are further entitled to have an attorney represent you during the course of that trial, and again, if you can't afford your own, the court can appoint an attorney for you. At that trial before your division judge, the state will have the opportunity to present evidence and attempt to prove up the allegations in the dependency petition. If the court determines that the state has in fact met their burden, the court at that time will order services for you to attempt to help you in the reunification with your child. If you consent to the allegations, you may further be ordered to complete services to help you regain custody of your child. In either scenario, the court will likely hold hearings for you approximately every 3 months to assess the status and progress of your services. You have a finite time to complete your services in order to regain custody of your child, whether you consent to the allegations or whether you have opted for a trial. If you do not complete your services in time, or you continue to engage in the same behaviors that cause the court concern for reunification with your child, the Department of Children and Families may file what's called a petition to terminate your parental rights to that child. If that occurs, you again will be entitled to the services of an attorney as well as a trial before your division judge on that matter. Because we are part of the Unified Family Court, if you have a case pending in the Dependency Division and also a case pending in one of our other Unified Family Courts, to include the Domestic Violence Court, Family Court, or the Juvenile Division, those cases may also be transferred to your Dependency Division so that your family may have one judge oversee all your cases. Our goal in the Dependency Court is to keep the children of Broward County safe and stable, and we work very closely with the families, the parties, and the agencies that come before us every day to achieve that goal.